Thank you very much, and good afternoon to everyone. Since you didn't tell the lawyer joke, I can do that on your behalf. What's the problem with the lawyer jokes? Does anyone know the answer? If not, the problem is that other people don't think they're jokes, and the lawyers don't think they're funny. All right, with these words, very nice to be here. My name is Kalle, and I come from the law firm Krogerus, where I head our technology and data team. And
I'm Iiris, Rantanen, also part of the same team as senior associate at Krogerus. I joined Krogerus 6 months ago, and before that I worked at the Court of Justice of the European Union, so interpreting EU law.
Great, and EU law is what we are going to talk about today. So what we'll do is we'll give you a very sort of brief wrap-up regarding some new EU data-related laws with focus on particular one law, because frankly speaking 20 minutes is a very short time, so we'll try to focus on what we think is at the moment the most burning piece of regulation that is in the pipeline. So with these words I hand over to Iiris and let you start.
I want to start with just a thought. The European data strategy started in 2020, and the EU Commission said that the aim of the data strategy is to make the EU a leader in a data-driven society. Creating a single market for data will allow data to flow freely within the EU and across sectors for the benefit of businesses, researchers, and public administrations. Let's say that this is quite an ambitious goal. In a way, it is a very big change in the way that businesses should function. Also, we can compare it to almost like the GDPR that changed the way of thinking of how personal data can be used. Here also we are trying to change the way that data is used. It's no longer just something, a commodity that enterprises can use by themselves. You have to have permission to use data, and you need to share data. So you need to kind of rethink the way you are functioning. Just a brief reminder of the EU's data strategy. We consider that it consists of 5 main elements. Firstly, the Data Governance Act that entered into force in 2022 already. The Data Governance Act, DGA, concerns data sharing practices. For example, when public sector entities have some kind of data, they need to share it for reuse purposes under certain conditions. And DGA also creates mechanisms and, for example, intermediary services for data sharing. Then the second one, we can discuss DMA and DSA together, the Digital Markets Act and the Digital Services Act. The Digital Markets Act is a more competition law-based approach. It concerns mainly the gatekeepers, such as Meta, Facebook, Google, Alphabet, and it forces them to open up their platforms so that small and medium-sized enterprises can also benefit from their platforms under certain conditions. And then Digital Services Act concerns smaller businesses as well, online platforms, and the aim briefly is to ensure that these online platforms they look into the content that they have on the platforms, and they try to prevent illegal content. And they also try to make these online platforms be more transparent when it comes to their advertising policies, as well as content moderation practices. Then the Artificial Intelligence Act, that is the latest one. It's still not in force. The Parliament adopted the AI Act in March, but there are some technical steps before it enters into force, but we expect it to happen during the springtime. The Artificial Intelligence Act in Europe is a risk-based approach, trying to make sure that AI practices in the EU function under European values, such as human-centric AI, AI literacy in companies, and certain course, that they abide with fundamental rights in the EU. And lastly, the Data Act, which concerns products that are connected to the internet and the data that these products produce. And Kalle will discuss a bit more on the Data Act. We will concentrate on the Data Act today.
Yes, indeed. So as we had to pick and choose, we focused on this one because this is indeed, in my opinion, something of a sea change in terms of how data is or how it will be shared in the future. So first, a couple of words about the key aims of the Data Act. Basically, what this strives to do is essentially empowering the users of connected products. And users in this case can be private individuals or they can be companies as well. The idea is to give the users the right to get the data out of the machines and related services so that they can use it. The other aim that the Commission has is basically to create new business, so to foster and to enable new services being built based on the data in the form of various types of aftermarket or repair services or other value-added services. So if the user wants that his or her machine's data is provided to for instance, maintenance service company, then that needs to be done. There's also some emphasis on SMEs, basically in the sense that they are free to some extent from the data sharing obligations, which we'll discuss in a few moments. And also there's some mentions about the public sector who have the right to receive data in some situations. Also, there's a separate chapter regarding switching between cloud services, which seeks to enable and make that easier and less costly for the users. So it's really quite a wide package. Here, just a few key terms and concepts. So what the Data Act is about and what it focuses on is basically connected products. So basically they can be any sort of products, whether it's a smart refrigerator or a paper mill or a consumer electronics piece. It's really horizontal, so the scope of different products that it encompasses is wide. It also covers related services, so these are, for instance, software or data platforms that are connected to these connected products. The data that is then the crux of this thing, it's either product data, so data that comes from the use of the product, or related service data, so the same thing with regard to these related services. And as a subcategory, we have the readily available data, which is really the part of the data that then needs to be shared. If you translate that into layman terms, I think you could talk about raw data. So that's the part of the data that needs to be shared with the users and third parties, if the user so wishes. And thirdly, we have the roles. I'm not going to go deeply into this, just to mention that in order to understand how the Data Act works, it's essential to understand what role you play in it, whether you are a data holder, a user, or a data recipient. Let's have a look at this in the form of a couple of examples. So firstly, data sharing obligations towards users. So in this picture, we have a user, which can also be, and oftentimes is a company, and we have the data holder, which could be, for instance, a device manufacturer on the right-hand side. And essentially what needs to be done is that when the user uses the product, which could be anything from a paper mill to a car or a refrigerator, if they use the product and that product creates then data, then if the user so wishes, the data holder must give that data free of charge to the user. So really it must be free of charge and it must be either readily available from the device directly, or if that's not the case, then based on a request by the user that must be made available to the user. No charges for this. Then the other scenario is the data sharing towards third parties, and this is perhaps even more interesting. And this is the part that I mentioned in the beginning, which kind of seeks to create new business. So if, for instance, in this example, I or my company is the user of an industrial machine, and I want to have that machine repaired or maintained by a third-party service provider, then the data holder, which could be, for instance, the device manufacturer, must give that data to this third-party service provider. So this is how it's going to work. There are some certain tensions in this, as you can probably expect. So, for instance, it's very much possible that the original data holder, so for instance, the device manufacturer, is a competitor of this third party, but nevertheless they must give the data to this third party in order for them to be able to perform the services that the user has requested. And this creates tensions, for instance, as regards the protection of trade secrets. That's a topic we could talk about in length. I'm not going to do that today, but just maybe suffice to say at this point that there are certain mechanisms in the Data Act that seek to protect the trade secrets, and that at least seek to give some comfort to the poor data holders. Whether those will be workable, whether they will be sufficient, that remains to be seen in the future, but there is at least something in the legal text that seeks to protect the trade secret aspects. But maybe just sort of to summarize this part before we go further and say a few words about data spaces. Why I said that I think this is a sea change and a big change in paradigm is basically that when it comes to data sharing up until now, especially between businesses, that has largely been based on voluntary arrangements, voluntary agreements between parties, which have been or have not been done and entered into. And typically, or at least in many cases, the balance of power has been rather imbalanced. So if we have a data holder, for instance, a device manufacturer, which is a large company, and we have a user company, which is a small company, it may well be that data sharing doesn't really take place. And that's about to change. So basically, starting from next September, next year, September 12th, this will become mandatory. So it's no longer an option not to share the data that is generated in connected products or thereto related services. It's a must. And another sort of big, at least from a lawyer perspective, big change in paradigm is the fact that also the contractual relations, those will also be regulated on a mandatory basis. So the Data Act has a full menu of different types of contractual terms that will be considered invalid. Those would be, for instance, such that would deprive the user of the right to receive the data free of charge, or that would delimit the data holder's liability with regard to the data, and so forth. So this whole sort of contractual setup will be regulated based on mandatory laws. In my opinion, this is a big change. So far, we've been used to having this kind of regulation in consumer relations. So we have the consumer protection law, for instance, which is mandatory. Businesses must obey to that. And now we will have something similar also between companies when it comes to data. Maybe one more thing before I let Iiris continue on data spaces. It's good to keep in mind that the existing old regulations will not go away. The GDPR, for instance, will still keep on applying. These just need to be applied in parallel. So from next year, September onwards, you have at least two parallel regulations that sort of deal with more or less the same thing. The GDPR looks at the personal data. The Data Act looks more at the industrial, non-personal data. Both need to be adhere to. So that's just a reminder. It will not go away. Great.
And the same applies to the Data Governance Act and the AI Act as well. So these acts do not present new legal basis for the processing of personal data. You need to still apply the GDPR in parallel with sharing data. And the data can be personal data as well. It can include personal data, so that it's a bit of a pickle. You need to share data, but you also need to have a legal basis for sharing personal data. Fun, good times. Just shortly on the data spaces, I will really speak very shortly because I think we've had very interesting talks about data spaces already. It's less of a legal big instrument. We don't have a common European data space regulation at the moment, but the Commission aims for sector-specific approaches to European common data spaces. And as you know, these data spaces are meant to be sector-specific in manufacturing, health, public administration and science, and agriculture, energy. The aim is to overcome existing legal and technical barriers to data sharing. And this is where we come back to the Data Act and the Data Governance Act. So the Data Act is meant to force companies and entities to look at the data they have, recognize the data they have, recognize the products that they have and the data that the products produce, and figure out how to share that data with third parties, with the users, and in that way kind of create the market for data sharing. And then the Data Governance Act enables the sharing of such data through, for example, these intermediaries, and also through certain obligations for public entities to share their data that was previously protected. Of course, there are sector-specific approaches, legal approaches already, such as the European Health Data Space Regulation that is upcoming, and I think more regulations like this can be expected with cooperation with the sectoral entities.
I think there's possibility of up to over 10 different sort of sector-specific data space regulations. That remains to be seen. The EHDS is the first one that has come out of the pipeline so far.
Yeah, exactly. And then, of course, guidelines can be expected from different administrations. So far, the Data Governance Act founded the European Data Innovation Board, and guidelines are expected from this board, but so far the work has only begun. And I think what's interesting in the data strategy is that it's really a new way of thinking, legislation-wise as well. And we don't have a lot of guidelines or other like soft law instruments from the EU Commission. So actually it's the companies that need to apply the new data regulations first. You are the ones, as well as we in law firms, that are forced to interpret the exceptions and derogations from the data sharing obligations in practice, and then we have to wait a bit before the courts give guidance on how to interpret these pieces of legislation, and for the guidelines from the European Commission as well as national administrative entities as well.
Great, we've almost used our time, so just to conclude with a few words regarding what should a company do, especially with regard to the Data Act, which, as said, will start to apply next year in September. If I just try to summarize this very briefly, where it starts from is actually the companies knowing their data and understanding what they have. If you sort of have no data governance, it's going to be very difficult to comply with these obligations. You should be able to distinguish between different types of data, what data is within the sharing obligations, what part of that is personal data, what is non-personal data, what is possibly trade secret. So that's really where it all starts from. So that's one thing to maybe remember from this presentation. Obviously, you need to understand whether and to what extent your products or services are covered by the Data Act and what role you play under the Data Act. That's where it all starts from. Once you've done this exercise, you need to start thinking about the more practical stuff, including, for instance, how and to what extent your current contracts, your sales terms, and so forth need to be renewed. But really start with the basics and get your data straight to begin with. Thank you very much. It's been a pleasure. We've run a few seconds over time, but I'm almost there.
It was
Thank
a
you.
scratch on the surface. We
Yeah.
could talk about this for 3 days, let's say.
Yeah. Thank you so much.
Thank you very much.
Thank you. Can't wait for the 3-day seminar on the Data Act.